House Bill number 370 by Representative Stokes. It's an act amending Title 22 relative to prescription drug benefits for persons with stage 4 advanced metastatic cancer.
Senator Ward.
Thank you, Mr. President. Members, House Bill 370 by Representative Stokes prohibits a health plan from requiring patients with stage 4 advanced metastatic cancer to have to undergo step therapy if the use of the approved drug is consistent with the best practices of treatment of the stage of the advanced cancer. And so essentially what step therapy is they may have to go through certain types of treatment before they can, or to eliminate I guess what they would consider more cost effective until they can ultimately get to what they know will definitely work. And so what this bill would do would eliminate them having to take those steps, because in many cases, or in all cases, time is of the essence. So we want to make sure that they can get the treatment they need as soon as possible.
You have amendments on this one, Mr. Secretary?
First set of amendments sent by Senator Mills is set number 3097, 3097.
Senator Mills.
Thank you, Mr. President. Members, is it 3097? Because I know we have so many of them. Just want to make sure. It's 3097?
3097.
Members, I had a call from Blue Cross, and they basically said, listen, could we find a way to make this work for the patient? And can we find a way to make sure that we don't have just a tremendous price tag on this? So yesterday, Representative Stokes and several patients that were wanting this legislation, we met and we came to an agreement on this amendment, and we spent a long time on it. And what this basically does is it gives the physician an opportunity to make sure that the medication that's prescribed for the cancer patient is prescribed. But if there's a drug that is clinically and therapeutically related with the same efficacy, that means the same result, then that's kind of where a determination can be made. And so basically in the insurance committee, the entire amendment was stripped out. A hybrid has been put in, and late yesterday afternoon, Representative Stokes said, listen, we're in agreement. If we can have this exact language, we would be fine. I talked to Blue Cross. They said if we could have this exact language, we could be fine. So I think this is good for the patient. But if there's a $10,000 drug versus a $1,000 drug, and they're chemically equivalent and they do the same thing, it would be good for everybody.
All right. Senator Ward, do you have any objection to the amendment? Is there any objection to adoption of the amendment? All right, stands adopted. You have further amendments, Secretary?
Next set of amendments sent by Senator Gaddy is set number 2943.
Well, Senator Gaddy, let me get those out to the members. All right, Senator Gaddy, you want to start explaining it?
Thank you, Mr. President. Yeah, we had some very touching and traumatic and emotional testimony in the insurance committee when we talked about metastatic cancer. And one of the folks that testified gave me a book written by her son, and it was very touching. I'm not going to read the whole thing to you. I'm not going to read any part of it to you, but Kelly Beckman testified. And at the end, at the beginning, she told us a story about how she heard a hollow sound in her head in the shower one day. And at the end of her testimony, she pulled back her beautiful hair, and she has a completely bald spot that runs from kind of her frontal lobe all the way back. With the hollow noise she heard was the hole made by the tumor in her brain. And so we talked a little bit about her situation, and many of us have had folks who have struggled with cancer. or struggled with different medical issues, and there's a delay that happens, and when that delay happens, sometimes the person seeking treatment dies right before the treatment is approved, or their condition worsens or decreases because the treatment is not approved in a timely fashion. And what she told us was that her doctor said she needed a certain treatment, and the cancer had metastasized through her body, and she needed this kind of treatment. And some folks in another state on the phone kept telling her pharmacist and her doctor, no, I want you to jump through all of these hoops before you get her this treatment, and the bill fixes that. But there's still a question that lingers out there of what is her family's, how do they encourage the effort to have this treatment approved in a timely fashion so she can get the treatment she needs when she needs it. And so what this amendment does is says, notwithstanding any other provision to the contrary, and in addition to any other right or remedy provided by law, the failure to comply with the provision of this subsection shall be considered an act or omission giving rise to civil liability, and such civil liability shall not be subject to any law of this state otherwise limiting recovery of damages. I see there's a question. I'll answer questions.
Senator Donner, you got a question?
So, Senator Gaddy, with the conditions that you gave us about that woman, and does she have any legal remedy without your amendment?
You know, I asked the staff about that. I've asked several folks about it, and they said that currently she may, and I'm not going to speak for the staff, but currently there may not be a legal remedy, or her legal remedy might fall under, if it fell under medical malpractice, it would be capped. It would require a lengthy process. This would allow someone who has cancer, whose treatment is being slow played under, because this bill is great. The bill the way it is great, and I hesitated to put this on it. But after speaking with the Komen Foundation and some others, they were, I sensed that there was a concern about where's the teeth in this if they continue to force them through all the different step therapies, and there's a detrimental result. So what this bill, what this says, just kind of clarifies, you have, notwithstanding anything else in the bill, you still have a civil right of action to bring to ask for a quick remedy, maybe if the treatment's needed within a couple of weeks, you could go to the judge and say, Judge, we need you to look at this. We need you to look at this under a microscope and determine if we can get this treatment done. So I didn't want this to get caught up too much, but I hope that answers your question at some extent.
Yeah, so my question was, if this law and your amendment is not in place, don't those people already have right to legal remedy with the laws of the state of Louisiana if what they did was this bill puts into place the elimination of step therapy, essentially, so that they go right to the drugs that are most necessary or most effective, and then if they don't do that, that would be in violation of the law, because this would be the new law, correct?
Right. And what that's correct. And what this amendment clarifies is that any civil liability shall not be subject to any law of the state otherwise limiting recovery of damages. So if they would have told her, hey, you're going to have to go through another 6 months of therapy A before we give you what your doctor wanted, and she was to pass away, well, then her family could look into her cause of action, and they wouldn't be limited by the medical malpractice cap or any other things that may limit damages to $5,000 in attorney's fees. There's throughout that code. So I would just, that I've seen. So it would not limit that, because we're talking about metastatic cancer spreading through the body. Time is of the essence, and I wanted there to be some teeth in the bill. I didn't want us to pass the bill thinking we're going to help people, and then what's the penalty if someone withholds treatment? And that area is not clear at this point. But I do believe they'd have a civil action. I just didn't want it to be limited if it was one of our constituents.
I understand, Senator. What you're doing is you're going to try to get rid of the malpractice cap in the state of Louisiana by using this clause in the bill. It wouldn't be subject to any malpractice cap, which is the current law, correct?
I don't think that's the current law, but I could see a doctor out of state sitting on a phone somewhere saying, well, your wife doesn't deserve that treatment because I disagree with your doctor at the Mayo Clinic. And so they can do that because they're shielded by some form of a cap. And then if something happened to your loved one, you know, you would be subject to that cap. But this is not I didn't want there to be any inference that this would be any adverse activity towards the patient that would be in violation of this statute would fall under any cap.
I mean, I understand what you're saying and understand all the circumstances and how difficult they are, but the amendment says such civil liability shall not be subject to any law of this state, otherwise limiting recovery for damage. So, I mean, I think this amendment speaks for itself, and that's exactly what it does. I don't think it's necessary. I think the laws are already in place. A violation of law, somebody can bring suits, they can go through the malpractice, they can get up to $500,000 for medical malpractice, and this would allow the attorneys who are suing to bypass that medical cap, which is in place in the state of Louisiana.
But once again, with metastatic cancer, time is of the essence, and we want there to be some leverage on the person 1,000 miles away on the phone telling your doctor, we know your law says that in Louisiana, that we can't do the step therapy, we're going to do it anyway. And then when that person calls your office as a senator or calls a lawyer they go to church with, the lawyer will read the law and say, I'm not sure you have any access to quick civil justice. And then we've passed a law that makes us feel good, but there's not really any road to leverage the treatment that's necessary and immediate.
This doesn't say anything, Senator, about quick action. It just says that, you know, if you need quick action and you don't get it and you die, well, then the attorneys who are handling the case can ultimately sue for whatever they want, and they don't have to worry about the medical malpractice. This is just a method of getting by it, and you keep talking about all these horrible cases. Listen, I understand the horrible cases because I live a horrible case, but I just want, I know what this amendment's doing.
So thank you. See, no other questions asked for acceptance of the.
Senator Ward, you have any objection to the amendment? No. Senator Donner, you have objection. Did you want to come speak on it, Senator Donner?
Members, you heard it in my line of questioning. I mean, it eliminates the civil liability cap for recovery of damages on these particular cases. I don't think that's what we ought to be doing in the state of Louisiana through an amendment to a decent law that's being presented. So I'm object to the amendment.
Senator Johns, you wish to speak on the amendment? What? He withdraws the amendment. All right. Any further discussion on the bill? Senator Ward now moves, asks the machines be open to add co-authors to the bill. If you wish to co-author this measure, please indicate so. Yes. If you want to co-author it. Senator Gary Smith, yes. Senator Cortez. Senator Barrow. All right, close them up, please. Adding 24 co-authors. Senator Ward now moves final passage. Machines open. Those in favor, vote yes. Opposed, no. Votes machines, please. Votes machines. Senator Barrow, yes. You through voting? Senator Martini, yes. Senator Price, yes. You through voting? All right, close them up, please. 36 yeas, none of the bill final passage. Reconsider vote. Let them object.